This project is one of those things, not quite that I stumbled into, but I backed into it in a way. And in my view, I'm not sure my collaborators think this, but in my view, it's still not jailed, it's still incomplete, and the big finishing project has yet to be done. I'm hoping that we will do it, and since I am the junior partner in this trio, I'm hoping that my colleagues will agree to this. That is, years ago, I somehow was asked to review a book edited by Terry Halliday, a New Zealander, known to many of you now at the American Bar Foundation, and Lucien Carpic, a distinguished sociologist at the École de Mines in Paris, both leading scholars of the legal profession. And I read their book and I reviewed it and I loved it, and then I also criticized it, saying you forgot to talk about judges, which is my thing, and you should have, and I suggested ways that they might have done it, and a few months later I got a telephone call from Terry saying he wanted to talk, and your ideas are interesting, so I became a partner in the ongoing enterprise. So what I'd like to do tonight, and I hope it is not too satisfying to you, because it's an incomplete process, and I want to identify some dots or different points. Then I want to draw some lines between them, but what I don't have is a nifty, complete, well-packaged argument like I had last night for some of you that were there. So this is a product in the making. So let me just identify several different issues, and then try to connect them, and then try to look at some of the implications. First of all, my talk tonight will emphasize will complain about the separate silos of disciplines. Now, this ought to be, I'm speaking to a receptive audience given the nature of this law faculty, so I hope you'll appreciate this. But anyway, let me identify my particular concerns here and hope I can draw you along. For the past 30, maybe 40 years, maybe longer, but at least 40 years, I guess 35, 40 years, the study of the legal professions in the United States, and I think England, and I think maybe worldwide, to the extent that there is a distinct project of studying legal professions, has been dominated by several people who have focused on the material benefits that the bar can bestow on its members. The leading person in this is Magley Morson, who wrote a book on the professions, focusing primarily on law and medicine in the late 1960s, early 1970s. Her argument was picked up by Rick Abel, and Rick parlayed that into half a dozen, 8 books, I don't know, arguments, variations. He didn't repeat himself too much, but it became a major book. Another pair that has also had a variation on the same thing are Bryant Garth of the American Bar Foundation and Yves Desolé, a Frenchman working in the Netherlands, have written 4 or 5 books. The most recent one, Lawyers in Asia, and International Lawyers in Asia, and they've done much the same thing. And there are still others working on these. In one way, and Garth and Desolé follow the French thinker that argues that the professions are designed to maximize status. So in both cases, Abel argues that the organized bar has as its primary, and if it's not its sole function, the creation of a monopoly right, a monopoly to practice law in order to enhance enhance income. And Desilets and Garth have a variation on that, saying that the bar is structured to pursue an objective that maximizes status, following those arguments. So this by now is the conventional approach to the study of the legal profession, maybe the medical profession, and others, but certainly the legal profession. And there have been lots of people working in the way. Terry Halliday and Lucien Karpik were early dissenters and continue to be dissenters, and they seduced me to join them midway through the continuing project. Both Terry and Lucien, independently of one another, Terry studying the American Bar Association, the American legal profession, and Lucien in a magnum opus, a history of the last 800 years of the Paris Bar, came to much the same conclusions. Namely that the organized bar has as one of its several functions the effort to promote the autonomy of law and the autonomy of the legal profession. So they took seriously, both good sociologists took seriously some of the arguments that Talcott Parsons, great sociologist now in great disfavor, had made about the legal professions, namely that the professions by definition had a public role and a public responsibility. And so he keyed into the traditional notion of the profession as a calling. I think he secularized the argument, but argued that the legal profession, as the other professions, wanted to maintain a degree of autonomy, the legal profession of the law, and that lawyers had a stewardship in fostering and protecting the autonomy, or maybe quasi-autonomy, of the law. That is, it was not only their calling, as it were, and their public duty, but it was in a sense in their self-interest. They were the high priests of a special calling, and they had the knowledge, and they wanted. So that was Parsons, and in some variation, both Terry and Lucien argued that this was the case. They found, independently of one another, that lawyers periodically throughout history would, in the two different countries, would appoint themselves or assume a role as spokespeople in behalf of an autonomous law or the rule of law or a quasi-autonomous law on one hand, and they would address an imagined audience that says this is what the law requires. And what they found that time and time again, lawyers were at the forefront. They didn't always win. In fact, they probably mostly lost. But they were at the forefront of challenging autocracy and authoritarianism, and particularly executive fiat, insisting insisting on basic core principles of political liberalism. Those consisted of several things. One is the idea of the moderate state, where there were checks of power. Another one was that certain basic fundamental due process rights apply. The right to trial, the right to judicial independence of trial before an impartial judge, and the right for and the idea of a robust civil society, that civil institutions, that civil society institutions could exist and occasionally challenge and compete with the state for the affections of citizens. And they found that when, during periods of authoritarian rule, and that lawyers and the bar were attacked or subdued, or an effort was to subdue them by the state. The bar would be taken over by the state and would become a branch of the Ministry of Justice or something like this. Lawyers would be harassed and the like. So lawyers, in a sense, in a very self-interested sense, said, we are the stewards of the law, not the executive, and we will identify the limits and the nature of that law, and when it's exceeded, we will respond to protect our interests in the maintenance of the rule of law. Okay, that's one thing. A second issue that's closer to home, because I am not a student of the legal profession. Indeed, for many years thought it was a boring sort of esoteric study. They made it exciting to me, but then I saw the connection with courts. As a political scientist, I have been studying courts since graduate school, and that's, as you pointed out, that's the thing that connects all my interest is in the institution of courts. Now, one of the standard questions that political scientists have asked about courts for decades now, at least for the past 40 years, is can courts affect social change? Can they bring about significant social change? And almost invariably, the answer is no, or not very much. Courts are truly the least dangerous branch. Now, the problem with the political scientists is they've been looking at courts. And the problem with the sociologists like Terry and Lucian is they had been looking at the legal profession. And they had not been looking at both. And when I was asked to review their book and said it's really terrific, but they ignored courts, one of the things I said when I elaborated that argument is that courts are not going to be powerful unless they are part of an epistemic community, unless they have lawyers to listen to them and hearken to their words, but more importantly, even before that, lawyers who have created the vocabulary, the grammar, the syntax that they use in which to define and articulate and elaborate rights. So thinking of courts without lawyers and thinking of lawyers, at least in the way I'm thinking of them, the public role of lawyers, without courts misses an important connection. I mean, it's impossible. Now, this is clearly more true, or at least true with a vengeance in common law countries, where lawyers are members of the bar and judges are judges are members of the bar, and they're recruited in mid-career, late career, and they move back and forth in a way that might not be the case where there's a bifurcation between judge and lawyer in a variety of other countries. Okay, so that's two elements I want to talk about. Let me mix in a third, and then I'll try to begin to connect. As I said, I'm a political scientist, and while I focused on law, I've also tuned in to my colleagues, to some of the traditional interests in my colleagues. And in comparative politics, one of the standard questions is, what are the causes and conditions of stability, the moderate state, political liberalism? You know, what are the causes and conditions of good government in this tolerant, open government? And this is one of the traditional concerns of students of comparative politics. Now, they have primarily, in trying to answer those questions, focused on a short list of politically salient concerns. They focused on class, not surprisingly. They focused on political parties. If you don't have competition and turnover in one party state, all sorts of bad things are likely to happen. They focus on market and the markets and the economy. What sort of market and what sort of economy takes place. They focus on the military, another regime after all, that controls the sword, and they focus on the church, the institution that controls the soul. All important institutions. But until recently, they have not focused a whole lot on constitutionalism or the rule of law. Now, Martin has been making this point for at least 30 years since I've known you, and probably long before. But comparative politics scholars have tended to ignore this. And one of the people that dropped a bombshell among comparative politics scholars was an Argentine scholar who had to leave, like lots of scholars, in the 70s and ended up in the United States, Guillermo Bodano. And Guillermo, trying to understand what went wrong and what could go right in Latin America, pronounced something that those of us interested in law and society had assumed, but it was a revelation to Guillermo and to the comparative politics, namely constitutionalism and the idea of the rule of law, the deep idea of the rule of law, may really be important. Institutions matter, and the new institutionalism and Guillermo was one of them, has identified constitutionalism and the rule of law important. Incidentally, I've just been reading a marvelous book by one of your erstwhile colleagues, David Neal, who wrote the dissertation at Berkeley, and then this wonderful book on how it was that New South Wales could become a wonderful democratic society emerging from a penal colony. And his theory is the rule of law, even in its absence and when it's being violated, honored in the breach, is nevertheless present and is used to constrain executive fiat in a variety of ways. So, I'm wondering what's new. I just read David's book, and I think he may say it all, so I'm a little embarrassed. At any rate, what I tried to do in this is bring in the political science dimension to suggest that judges are important players in this process. It's not lawyers alone, but it's judge and it's lawyer and company, or judge and co. To paraphrase the Kipling, wonderful Kipling short story. So the expanded view, we coined a term, and it is used in the latest book. I left. None of you can afford to buy. I can't afford to buy it, but I gave one of my free copies to Martin, so you can borrow it from him. We coined the phrase the legal complex, and by legal complex we mean the bar, the bench, and in the 20th century another important component of lawyers is academic lawyers. As the academy has gone large and institutionalized and relatively wealthy, it too, and with all its publications and its prominence, is another component. And there are other components of the bar, lawyers as well, prosecutors, government lawyers, in a variety of ways. Now, not everybody that has a law degree, or we say part of the legal complex, but we're suggesting that there are a variety of identifiable institutional lawyers who do identify as lawyers and often speak in the name of law. That is, they assume a role as spokespeople. They just assume the role of spokespeople and create an audience, and they're speaking in the name of law to a group, to civil society, suggesting what law can and cannot do and ought to do. Now, our work is basically empirical. What Terry and Lucian and I have done and they did first and then I joined them, is commission a series of case studies. We've identified smart people who are immersed in one area or another, and we've asked them to, we've given them a framework or a set of questions, and we say, answer our questions as best you can to tell us how members of the legal complex acted in this instance. And what we have asked them to do is identify moments of stress or moments of confrontation or moments of political crisis in the various societies in which they're experts on. Now, some of those people that we've identified, we now have 3 volumes, each has about 10, so we've contributions or more, so we have, I didn't bother to count them up, 30 to 35 contributions from a variety from all over the world. Some of the people you may know who have contributed to this, we have Andrew Harding and Amanda Whiting at Melbourne. We have one of their wonderful PhD students that at least Martin knows, Jyoti Rothja. Tom Ginsberg has looked at a variety. So we've drawn on, and I mention these because these people know wherein they're talking. We've given them a framework and a set of questions, and we've asked them to identify. It's not the best way to do research, but we found it was convenient given the limited amount of money we could get from the National Science Foundation, the American Bar Foundation, and the works have ranged, and the contributions have ranged from being really, really good to absolutely, drop dead spectacular in the country. Okay, so here are some of the findings that seem to be that are generalizations that we can draw from extracting the various lessons from the case study. I want to emphasize at the outset that we certainly don't have a deterministic theory. We certainly don't have a fixed theory. There are plenty of exceptions, and of course, any particular case study that we have is no doubt subject to lots of dispute by other people. But nevertheless, we see a variety of central tendencies that point pretty significantly in one direction. So we feel moderately confident, we feel very confident that we've identified something that is really significant. And so several of these things. One is the legal complex mobilizes around the autonomy of the judiciary and the autonomy of the bar. That is, members of the legal complex want an independent judiciary. And when executives start dismissing judges, or when judicial corruption, particularly at the highest levels, becomes evident, there's a tendency to respond and to strike out against it. Lawyers like the autonomy of the bar. They don't want the state telling them what the bar can do and can't do. Ideally and consistently, almost everywhere, lawyers want to identify who can become members of the bar. They don't always get that, but that's the ideal quest. That is, lawyers want to control entrance into the priesthood, and they don't want to see that taken over by the state. And so this is a constant struggle. So think of it. I keep wanting to emphasize this. This is some combination of idealism and the idea of the independent rule of law, and it's coupled with the idea that lawyers want to control their own destiny. We all want to control our own destiny in some way, and so there's a self-interest. So there's this marriage of self-interest and public regardingness, and how you play it out, how you tease out those two things may vary from place to place. Secondly, historically, the legal complex or lawyers have mobilized around core negative rights. T.H. Green's first order of rights. Those would include judicial independence. They would include freedom of expression, freedom of belief, and some degree of due process. They don't mobilize as well, and also it might be they mobilize around rights of property. This is not a liberal agenda in sort of a modern sense. They have not mobilized around the expansion of voting rights. They never mobilized around the expansion of voting rights in Hong Kong, even when they mobilized around the idea of free expression in Hong Kong. Okay, and they have not mobilized around women's rights. Now, obviously, a lot of lawyers have mobilized around these things, but we want to make a distinction between cause lawyers that have mobilized and have identified with very causes move, and a core set of rights that define the lawyer's very being as to what it means to be a lawyer, and that is those rights that are central to the autonomy of the legal order. Okay, so they mobilized around it, and many times they have failed. And when they have failed, it's often because the state, as in some societies, has either intimidated leaders of the bar or has turned the Bar Association into an agency or a unit of the Ministry of Justice. That is, that they've taken over, and occasionally they've taken over and continue to hold the prerogative of identifying defining who is a lawyer and who is. So they mobilized around a very limited set of rights. Thirdly, the lawyers are hardly heroes. Almost all of their actions, historically, have been reactive. They're not on the forefront. But when their prerogatives are challenged, some of them, in the name of the law, will mobilize to protect their prerogatives. So they're hardly champions of freedom going into it. And Terry makes the point in his book. It was the conservative, Republican, business-oriented lawyers in the 1950s who finally said, McCarthy is too much. Joe McCarthy has to go. He is an outrage to the public. These were not liberal ACLU lawyers. These were business-oriented, white shoe, Chicago and Wall Street lawyers that found Joe McCarthy an affront in his anti-communism crusades, violating basic rights and human dignity. Okay. Fourth, courts are often, but not always, the locus of these battles. Lawyers will speak out eloquently and often turn to courts and enlist the support of judges, or see at least some judges who again will speak in the name of the law. Now I want to emphasize this, that the role that we're talking about of both judges and lawyers is, in a sense, a self-appointed role. It doesn't come with the job description, necessarily. It's a self-conception of what it means to be a lawyer and what it means to practice law and what law means. And occasionally they will say, my dignity has been challenged. I am affronted, and I organize, and I have to speak out to protect not only myself but the dignity of the enterprise I'm engaged in. So it's a self-appointed role. It's not in the job description explicitly. Okay. Now, the point of that, and sort of my modest contribution to this ongoing project, is that at least in the last 30 or so years, with the rise of constitutionalism in Eastern Europe, in Latin America, and in Africa, and in Asia, particularly I'm thinking of Tom Ginsburg's work in Taiwan and Korea, with the rise of judicial review, and almost all post-colonial British colonies, unlike you guys, have maintained, on one hand, they've maintained a parliamentary system, on the other hand, they've had a written constitution that provides for judicial review. Not all of them, but many. Africa and Asia. And with the rise of constitutionalism, the challenge to the excesses of the rule of law has changed, and it's drawn, I think, judges more directly into the process. The traditional argument, historically, that lawyers would have, and you can think of your English legal history as a wonderful case about this, is challenging the excess of executive power, challenging the crown, and who ignores the rule of law as laid out by Parliament. But to the extent that you have a written constitution, Parliament too is brought within limitations. So the Constitution isn't in Parliament. The Constitution is what the judges say it is, and this has expanded the role of judges. And certainly in Eastern Europe, and in some places in Asia, and increasingly in Latin America, one sees judges taking on not only challenges of excessive executive power through the frequent use of emergency rule, because almost all of these new constitutions provide the deus ex machina of emergency rule, executive rule. Not only challenging those, but challenging the powers of the legislature if they violate the Constitution. So this has drawn the judges more directly into going eyeball to eyeball, not only with the executive but with the and in a couple of places, and one of our wonderful case studies is our series of case studies, 3 of them, looks at India, where emergency rule is declared by Gandhi. The court strikes it down. The National Congress Party has a supermajority in the legislature, parliament. It passes a constitutional amendment that allows us to, and the court comes back saying that it violates entrenched provisions. The new constitutional amendment violates entrenched provisions of the Constitution. And they have a notion of, and here they drew on German constitutional law. There are certain unamendable provisions in the Constitution, or if they are amendable, as the Indian case, if they are amendable, they have to be explicit, and they have to identify all the provisions in the Constitution that are going to be overturned by the amendment. If they don't do that, then the constitutional amendment itself is unconstitutional. We've seen some of this going on, at least this doctrine beginning to emerge, at least in dissents in the United States state courts. At any rate, you see judicial review has dramatically increased the power of judges worldwide. Other things are going on that do that as well. But again, what you see is judge and company working together, challenging challenges to the moderate, or at least reacting to challenges of the moderate state. Political liberalism would suggest a limited state, the right of civil society institutions to exist, and judicial autonomy. Now, this sounds rosy, and I don't want it to be so rosy, because in many cases, in the studies we look at, the legal complex loses, and it loses big. Political power can swamp both courts and the bar. But the heroic fight does continue, and when executive or governmental fiat does defeat these institutions, it's purchased at a high price, and these institutions come back again and again. Now, let me identify just, I've spoken very abstractly, but let me identify a few places, just hit some highlights of some of the case studies. Well, one of them is Japan, and one of my students from a million years ago is now a very distinguished sociolegal scholar in Japan, probably known to many. For all I know, he's taught here, Setsuo Miyazawa, a very distinguished Japanese sociologist of law, and I finally had the courage to write something about Japan when I wrote with him. And we looked at the role of lawyers and courts after the Meiji Restoration. And one of the interesting things, there was no real legal profession prior to the Meiji Restoration, prior to 1868. And of course, it was created, as you guys know better than I do, I'm sure, it was created in part to keep the United States and imperialists from invading and colonizing Japan. They said, we'll adopt a Western rule of law, so you don't need to come in and colonize us. And they very efficiently did that. And they dutifully sent large numbers of smart students off to England, to Germany, and to the United States to learn Western law. They adopted the French Civil Code and the German Criminal Code, and they modernized. But they sent a lot of lawyers to England, and they expected all these lawyers to come back and be civil servants and prosecutors. One of the things they learned was the heroic, as they perceived it, and I think correctly so, the heroic and wonderful status and importance of the solicitors and the barristers, private practitioners. So many of the Japanese law-trained kids that came back wanted to move into private practice. And almost from the outset, that created an adversary relationship between the legal profession and the state, because the state assumed that the law-trained people would be working for it, and these lawyers were in it, and that has continued to this day. Lawyers and a handful of judges, but mostly lawyers, played a heroic role in fighting for due process, fighting for judicial independence, well up to the late 20s and the 30s, when the bar finally capitulated to the military regime. Post-war, it's emerged again, and one of the tensions and one of the challenges in Japanese socio-legal studies is to what extent members of the judiciary are connected with the bar or civil servants. By and large, it strikes me they're civil servants. 1/3 of all judges in Japan are administrators, and their job is to oversee the work of the other 2/3. And judges in Japan that will rule that a confession was coerced. They live in Tokyo, may find their next tour of duty is in Kyushu or Hokkaido. They're forced out of office by just not being reappointed, or they're rotated to highly undesirable areas where the kids get good educations, and they resign. But you do see the Japanese bar is something, at least in the American parlance, is something like the League of Women Voters, a good government enterprise that is constantly organizing to challenge the government's fiat and trying to form coalitions with other civil society groups to challenge the enemy. Same thing happened in post 9/11 the United States. One of the interesting things about the post 9/11. Look, I come from Berkeley. My colleague is John Yu, one of the truly bad guys in this enterprise. But one of the things that the legal profession ought to take pride in, and all lawyers ought to take pride in the United States, is just how many lawyers volunteered time to deal with to represent the detainees in Guantanamo and other places, and how many more lawyers supported that handful of lawyers that did this. Furthermore, one of the groups of lawyers who are the real unsung heroes and paid high prices for this were military lawyers. Lawyers in the Judge Advocates Corps who were supposed to represent clients, within the military justice system, and did a great job of representing them to the extent that they were often relieved of command and mustered out of the force. The American Bar Association, various state bar associations, consistently supported the lawyers that did this. They didn't, the bar didn't come out and raise millions of dollars for legal defense, but they defended the lawyers. The Bush administration, at one point, for instance, tried to reach out to the clients of some of the blue chip law firms in New York and the other big cities, saying, "Don't go to Cravath, don't go to Debevoise and the like, because they're representing some of the terrorists." And these firms, to their credit, told the government to get lost, and the American Bar Foundation came out criticizing, condemning the government for even thinking this, let alone trying to affect it. And they quietly went away. At any rate, one finds this again and again and again. Okay, now we have 35 different case studies. Each story is different. It's hard for me to summarize, but let me identify what I think are some of the important takeaway points, and then I'll shut up. First, one finds consistently lawyers and judges fighting to protect a small number, and it's not the numbers that we're looking at, but we're looking at those who speak in the name of the law, and we're looking at the extent to which the organized bar is either participating in this process or is supporting this process of either judges doing this or of lawyers doing this. My central concern, and this may distinguish me from my colleagues in this, is that I envision this enterprise that I'm engaged in to shift in some significant way the nature of comparative politics. Remember, I began at the outset suggesting that many students of comparative politics want to account for differences among states, and particularly identify those causes and conditions that lead to moderate to politically liberal, tolerant states in terms of political party, class, religion, and so on. I now think that the evidence that we pointed to suggests that the idea of constitutionalism and the idea of the rule of law, that is, it's an idealist explanation rather than a material, as it were, explanation, simply has to be one of those core independent variables that, as it were, to use the political scientist language, that would account for variation among the same. And I think that in a variety of ways, I'm making the argument at a good time, because the new institutionalism in sociology, political science, law, economics is increasingly saying institutions matter, and certainly the law and the legal profession as an institution, as opposed to a group of, a set of individuals that are organized to pursue common goal, is a good example of the new institutionalism at work. And so to tell you where I want to end up is we have now edited 3 volumes with 35 case studies. I'm hoping the next time I'm here, and I'm hoping I'm here again, that I'll be able to report that we have a nice, tight, 200-page book that extracts the lessons a bit more systematically than I've just been able to do here, to suggest that, to demonstrate how the legal complex is a player, and a significant player, in contributing to political liberalism and the modern state. With that,
thank you. Maybe just a footnote about the Guantanamo lawyers, that we've had our own version of that in the lawyers who stood up for Dr. Mohammed Hanif, who was charged and arrested for supposed terrorist offences. Some lawyers acted very bravely in standing up for him. And we've also pinched one of yours, one of the ones that you talked about, the army lawyers, Dan Murray, who acted for David Hicks, and who has now become an honorary Australian. So
it's easy to become. This was my first trip to Australia. After all these years, this is my first. And this is this is the world's best kept secret. You guys are. It's fantastic.
I agree with that. On behalf of everyone, can I just thank you, and a small gesture of our appreciation. You'd be very glad to know that this is not some ghastly piece of UNSW memorabilia. It's an Australian book picked by Martin, which another law book you'd be glad to know. We hope it would be. Thank you very much.